Mr. Dickey, you may proceed.
Mr. Chief Justice, may it please the court, I'm Gary Dickey from Dickey and Campbell Law Firm, appearing on behalf of Kelvin Plain Sr., who asked this court to reverse his conviction for first-degree harassment on multiple grounds. First, Mr. Plain asserts that his right to a fair cross-section representation of the jury was violated when the jury panel from the Black Hawk County trial substantially underrepresented African Americans. Second, he asserts that the district court should have excluded hearsay testimony from the officer concerning allegations from his accusers. Third, Mr. Plain asks for a reversal on the basis of the prosecutor's repeated use of the term victim to refer to the accusers in this case. And finally, Mr. Plain asserts that the district court should have instructed the jury on the proposed implicit bias jury instruction that is commonly used in the Northern District of Iowa.
If I could ask you about the first issue, because I agree that you've identified a problem. I am very troubled by an absolute disparity test being applied in Black Hawk County. I agree with you on that. So what would be the standard that should be applied to a veneer that what's the statistical approach that should be applied?
What would be most helpful in terms of giving direction to the bench and bar from this court in deciding this case would be to allow an open approach that asks the attorneys in the courts to consider multiple statistical analysis in determining whether or not there is substantial underrepresentation. And we've submitted 3 that courts have commonly used in the context of Sixth Amendment claims: absolute disparity, comparative disparity, standard deviation analysis. And there's also a binomial statistical analysis that's used in desperate employment situations, that litigation context. You know, the United States Supreme Court in Durham has left that open. As the issue has percolated through the federal courts, you know, most courts will consider a host of statistical analysis before finding a decision.
I have a feeling our trial judges are going to want something more specific than that.
Well,
I mean, do you have a specific suggestion that at least maybe it's not the only solution, but in your view it would be constitutionally sufficient?
If you look at the comparative disparity analysis in this case, it would show that there is a significant problem, just reflected in the statistics in this pool. If you look at the standard deviation analysis, it would also support that view. So the standard deviation in this case, by my calculations, would be approximately 2.14. So you would expect to have approximately 5 African-American jurors out of 56. We only had 1, so we're more than 2 standard deviations. So if you think back to the, you know, your statistics, you're looking at the 68, 95, 99. We're past the 95% confidence level. That's a statistically significant deviation. So we have a problem on the second prong in Durham. We would submit either of those 2 tests would satisfy.
Which tests do most states use? I mean, out of the 3 tests, or even the 4th you suggested?
I've not done a comparative analysis of all of the states. If you look at the scholarly research, they suggest that the federal courts, at least, are looking at all 3 approaches. The comparative disparity analysis is particularly appropriate in states like Iowa, where you have the smaller pool, because the absolute disparity can never be satisfied.
Do states use different tests depending on their minority populations?
I mean, I don't know that if you're asking from one race to the other, or are you asking for percentage?
Well, there's all
of
kinds of
population?
minorities. There's Hispanics, there's Asians, there's people of color. I mean, there's all kinds of minorities, and it's whatever we do is not just going to apply to the black population of the state. But it seems to me, you know, you go down in metropolitan areas where there's a high concentration of minorities, one test may be better than the other. When you go out to a rural area where there's not a high population of minorities, a different test may be used. Are you asking us to leave it open depending on the situation, or is there some accepted test somewhere in this country that people can apply across the board?
So the short answer is no, there's not a specific one-size-fits-all approach. For a state like Iowa, under the current demographics, the absolute disparity test is not, it makes the Sixth Amendment right to a fair cross-section illusory. So we would specifically ask this court to overrule Jones to the extent that it's understood by the lower courts as applying absolute disparity to the exclusion of other tests. So in terms of providing guidance going forward, I think you've identified, Justice Wiggins, there are problems with all of these tests, given sample size, giving demographics. We would submit, based on the demographics in this case, that the comparative disparity or the standard deviation would be the most appropriate.
Counsel, if we do what you're requesting, should the court give any direction or insight with respect to how much data is required? In this case, counsel, as I understand it, went to the clerk and said, I'd like to have 6 months of data. Is that sufficient, or should it be more than that?
I think as a general proposition of statistics, the greater the sample size, I think the more confidence that you can infer from your analysis. If I understand, if you're asking about the third prong in terms of looking, is this a systemic problem, there should be two ways of proving a systemic problem. One is through looking at just the statistics. So for example, it's the Castaneda case from 1977 in the United States Supreme Court. I'm not sure we briefed that in this case, but the disparity was so large that in and of itself, that disparity is evidence of systemic problems and underrepresentation. So you don't even need to show the third element of the prima facie case. One other method would be looking over time. 6 months, I think 10 months was the time period in the Duren case, if that's available, which it doesn't appear it was in this case. Or I think alternatively, you can look at other factors, not just pure statistics over time for determining systemic problems, but you can look at the actual procedures that are used to see if you can infer some problems. So for example, in Burgess, the allegation in that case was that they were pulling in jury pools and then pulling out minorities, and that procedure was systemically problematic. It ultimately didn't sway the court because it had EDPA deference, but I think you can make a procedural argument setting aside the statistics to show systemic underrepresentation.
One question here. If you use any of these tests, say comparative disparity, do you do it to the jury pool at hand, or do you do it to the jury pool over a year, over 6 months? Because, if you gamble, you go to a casino, you might sit there and win at blackjack, and you might sit there and lose, but the house is always going to win over time, because over time the odds will even out. Do we look to see if the absolute or the comparative disparity, I would say, if that's what you're asking us to look at, or the standard deviation goes over a year period, and this one pool may be an anomaly, or do we have to apply these tests to each pool as they're assembled for each defendant? Does that make sense?
I think it does, Justice Wiggins. So ideally, you would do both. You can use the comparative disparity, the absolute disparity, the standard deviation, just on that jury veneer in the individual case. You can also look over time to prove the third prong of Duren. And then that's why I would propose that you also consider mentioning, to the extent you're providing guidance, looking at the binomial distribution, which takes a look, in this case, you would expect to have 6 jurors or 5 jurors of African-American background. You only had 1. Is that a reflection of the laws of chance? because it falls within the normal distribution patterns, or is it so disparate that it really reflects something more underlying?
Do you have any insight or any comments on the way jury pools are assembled that may or may not lead to this problem?
We mentioned in our briefs, Justice Wiggins, and this is kind of the second aspect of Jones that needs to be reconsidered by this court, and that's 607A.22, which uses voter and driver's registration as the two presumptive list, and then allows the flexibility to look at other, like public utilities. I think it's been well chronicled by this court in the last couple of years that we have that our felon disenfranchisement constitutional provision has a disparate impact on minority populations, most acute in the African American population in the state of Iowa. So to the extent we're relying upon voter registration, if we are incarcerating and more African Americans have felons, then it will funnel its way down through our jury pool selection process.
Can you identify any other potential systemic problem that would account for the lack of African Americans in that jury pool?
I don't have the data with respect to voter or with respect to driver's license, but to the extent that African American populations are disadvantaged economically, and that can be shown, and I'm not saying I've shown that here, to the extent that that there is a disparate impact on over-criminalization in the African American community, not just with respect to felons, but with respect to driving while barred, driving under suspension, and the other crimes that have collateral consequences with respect to driving privileges. You could see a systemic problem there.
What should be changed or done differently?
I don't have a good answer for that. The part of it is for the legislature to take a look from a policy perspective of looking at bigger sources of potential jurors to draw from that doesn't have a disparate impact, or alternatively fix some of the problems we have in the criminal justice system that is resulting in the over-criminalization in the African American population, in particular as it relates to this case.
I'll tell you where I'm really having a problem a little bit. Nobody disagrees with the proposition that we have a problem with our jury systems and the lack of disparity in or the high disparity in our jury pools and panels. I'll tell you what my concern is when we say that this is wrong, we reverse this, we say that the district courts must now go through and utilize the comparative disparity test and the standard deviation test or the other tests that we've now talked about. What do we do in the meantime? I guess I'm looking at it from a practical standpoint, and I think you're going to find, and I don't know if statistics would show, that maybe none of the juries anywhere in the state of Iowa really meet the test that you're requesting or requiring, or that you're saying that the Constitution would require. So what do we do in the intervening 2 or 3 years when we try to figure out what's going on with these juries? Because the first thing that's going to happen the week after this is that every jury is going to not be complying with it. You're not going to have any jury trials. So you see where I'm coming from? And just by your explanation, we all know this is a huge problem, and it has so many different facets to it that I'm really struggling with the idea of saying, yes, this is absolutely a constitutional violation, and what we've relied upon for the last many, many years, correctly or incorrectly, that's what we're all relying upon, is now going to go out the door without any reasonable solution that's going to be practical in the next 2 years, 3 years, 5 years. I think we've been dealing with this for years. Just kind of soothe my fears about this if you can.
So I'll make multiple points. First is, I don't think the opinion has to be drafted where you require the district court to adopt the comparative disparity analysis. I think it would be sufficient to overrule Jones to the extent that the absolute disparity test is the test to the exclusion of others, and then provide an explanation of why these other statistical analysis may be more useful in a certain circumstance. In fact, there may be a fourth or a fifth analysis that I've left out that may be even more relevant. With respect to the larger kind of policy issue, I will concede it very well may be the situation in Blackhawk County and Polk County and some of the larger metropolitan areas that we have a real problem with our jury veneers. And in the short term, it may require that some of these veneers get thrown out and we retry the cases. We have a legislature that is in session until April, and that's a policy question that they have to address. And I understand the consternation it provides to the court. What I would say is this court has repeatedly recognized that it's not an excuse to abandon constitutional rights because it's not easy to guarantee them. And to the extent we are considering the lesser evils and the choices presented in the values in this case, the evil of violating Mr. Plain's Sixth Amendment right and similar situated African Americans is by far and away the greater evil than to require multiple veneers in the interim. Thank you.
Thank you as well, Mr. Dickey. Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court, counsel. Good morning. It's good to be here. I agree this is an important issue that needs to be addressed at some point. I need to throw in a word for constitutional avoidance. Without an allegation of systematic exclusion, I don't know how we can really overrule Jones as to what's required to show substantial underrepresentation. I'm going to proceed with the argument anyway, but I think that needs to be considered.
I mean, eventually we're going to overrule Jones, maybe.
I mean,
right?
eventually we're going to consider.
I mean, I'm not a statistician like maybe I see a professor back in the courtroom, but it just strikes me as so statistically flawed that and I'm as big a fan of precedent as the next person, but if it's statistically flawed, why don't we go to a better statistical method and then move to that other issue that you've raised, which is there some form of systematic exclusion going on?
Right. I want to emphasize that it wasn't alleged even below or in the initial brief on appeal. But to talk about statistics, I want to talk a little bit about a binomial distribution. The equation's a little complex to say verbally. What you can do is go to, I use Wolfram Alpha. There are statistical tools where you can type in X successes in Y trials with probability equals P. In this case, you would type 1 success in 56 trials with P equals 0.09 for the 9% African-American population of Black Hawk County. When you take a jury panel of 56 people in Black Hawk County, you're going to get 1 African-American or fewer 3.5% of the time. This is entirely within the domain of random distributional chance. It's at the tail end of the distribution in some regards.
That goes to my question. Do you do it based on an individual jury panel, or do you have to look at it over time and see whether or not those panels continually only have 1 out of 56? You know, some may have 20 out of 56. Some may have 15 out of 56. I mean, we pick panels on a monthly, Polk County picks them on a weekly basis. I mean, so I guess maybe you can answer my question. Do we look at one case in isolation, or do we look at the panel over a period of time? Or does the Constitution require each individual to get a fair trial?
I think that you would look at it over time to prove substantial underrepresentation. The reason is because the Sixth Amendment guarantees the right to a jury panel drawn from a proportional section of a proportional cross section, of the population.
But here the information wasn't given to the defendant when asked for it, and
well,
so what's the remedy there? If that's what we have to look at, and the state won't provide that information, then tell me what the remedy is.
Won't provide is a very strong way to characterize what happened here. I direct you to pages 98 to 101 and then 104 to 106 of the record. What happened was this challenge issue was raised. The judge granted permission to relate the challenge back to before voir dire. The jury manager was brought in on this, and she said, I can't get the data from prior jury panels from this computer. Now, that data is available elsewhere, but counsel just abandoned the challenge entirely, didn't ask for permission to relate back with information that could be obtained. There was really no attempt to provide that. And I think that would it be a good practice in the future for that information to be available? I think so. I actually saw an article in the Iowa Law Review by Nina Chernoff that suggests that defense counsel, if they have a concern about this going in, that they should be filing a request for that data within a week before the date of trial in voir dire. And I think that fits with what we expect.
Your argument shifts to it wasn't preserved, is what I'm hearing from you.
I really do think there are profound problems with resolving this issue in this case, and that's one of them. On top of the failure to allege systematic exclusion in any form, there's also I just object to characterizing the failure of proof here as a problem for the state. The state could, or the court, the jury manager could have provided that data if given time to do so.
Doesn't the state have an interest in providing a defendant a fair trial?
Absolutely.
And it wouldn't be an incumbent when this comes up. I mean, this is no secret. I mean, we've had this problem for the last few years here. We've talked about it. I mean, isn't it incumbent upon the state, the county attorney, to say, well, maybe we should look into this, and maybe should we take a little time and get those figures?
I think a lot of people who've looked at this have ended up in the same place that Mr. Dickey has, where it's really not clear what the solution is. Part of the problem, I mean, whenever you deal with random sampling, you're always going to have swings one way or the other. I can tell you that a binomial distribution shows that your odds of getting 23 jurors called for voir dire and having 0 of them be African American in Black Hawk County, those odds are 11%. That's going to happen 11% of the time. If you look at before jurors were excused or disqualified or deferred in this panel, that's 63 total, 2 of them African American. That happens 5% of the time.
Just tells me we should look at broader numbers. And I mean, maybe it's our fault. The clerk works for us. Maybe it's not the state's fault here.
I think that it would probably be a better practice to have that information already compiled, but I don't think that, and we don't know what that information is. I would submit that when you look at and this is why I think it's important to look at more dates of the information, because you might find that this is an ongoing pattern in this county, or you might find that this was a particularly tail end of the distribution day.
Why wouldn't overruling Jones be a good start in going down that path? When Jones says you look at an individual jury panel, you don't look at the statistics, you're looking at this panel. Well, why wouldn't that be a good start in getting to where you're talking about?
So I think part of the reason why Jones makes sense is because when you have an absolute disparity that's less than 10%, the odds of having no members of that distinctive group are sufficiently high that just showing that nobody showed up from that group doesn't allege really substantial underrepresentation. If you've got a jury panel of 40 or of 30.
But if the briefs are correct that there's not more than 10% in any county of minority African Americans, you'll never have disparity in any case. So how does that help us by applying Jones?
I think that it's just a recognition of the fact that in any individual jury panel, the chances of no members of that group showing up are not so low that the fact that it happens demonstrates substantial underrepresentation. 4.2% of the time that's going to happen when your jury panel is 30 people.
What you're doing is, because you're really smart guys, you're developing sort of a statistical defense for something that it seems to me was kind of originally picked out of thin air and really doesn't have a statistical basis, right? I mean, shouldn't we go to something that's more sound?
I agree that when I look at absolute and comparative disparity, it's a little agonizing that there's no consideration whatsoever of sample size. In Mr. Plain's brief, there's a citation to Waller, like a Maryland case, North Carolina case, and they draw the line for comparative disparity at 20%. In this case, that would be, you would show that comparative disparity if 4 African-American jurors were on this panel, and that's even within half of 1 standard deviation from the mean. I think that's, absolute and comparative disparity are good for drawing a line to see, is further investigation of this necessary? It enables a quick decision by the trial court judge. But when you actually start to see, is there a real showing of substantial underrepresentation made, you need to consider sample size. You need
So
to
what
say,
is the sample size that should be used in a situation like this? I mean, is it 6 months of data or a year of data? I mean, what's your view on that?
I think it would be a good practice. I mean, this court gets to prescribe the rules that it wants, but I think a good practice is to try to use 6 months if available. Really, the line is, and I also think that there is a danger if we don't set out kind of a standard data set to use, there's a danger of cherry picking. I think that if the available data, even if 6 months of data isn't available, if the available data shows a level of that what occurred here is really, really unlikely to be explained by random chance and a probability that this is far off the tail end of the distribution, I think then you can show substantial underrepresentation. Now,
As Justice Zager observed, this is a multifaceted problem, and are there studies that show that using more, putting greater reliance on utility bill lists would increase the number of African Americans?
There's data that goes a lot of ways on that. One thing that is pretty much universally confirmed is that utility lists introduce a male bias but that doesn't really solve the issue we're talking about here. It goes both ways, and I know that it's discretionary under the code to use utility lists. I want to point out that under prong 3 of Duren's systematic exclusion, I don't think it's enough to show a numerical disparity over time. I think you need to show that numerical disparity is due to an inherent problem with the system used to compile the list of potential jurors. I think that you need to show something like in Osorio, the Connecticut case, where everyone who lived in Hartford, Connecticut, was accidentally marked deceased by their jury system. I think you would need to show that this isn't the product of the aggregation of individual choices made by people who receive the jury questionnaires and make their own individual decision about how to respond to that. I think you need to show that something the state is doing in compiling those lists produce a disparity or an exclusion that's
that
inherent.
just seems like, it does seem like kind of a cop-out to me to say that you have to show this disparity. I think the solution is to figure out how you get more people involved in it, whatever it is, instead of just saying, well, no, we use the utility bills, we use whatever variety of things that we do to try to get people in there. And I don't think then you can say, well, we've done everything we can, we tried, and it's just not working, and so we don't have to deal with it anymore. Or you haven't shown a systemic disparity that's created by the state. So I don't necessarily agree with that as being an appropriate response to the issue or the problem.
I think that it would be different if we were still just relying on voter registration lists. We are using also driver's license and non-driving ID lists, and I think that mitigate whatever, and this isn't alleged till the reply, but whatever part of felon disenfranchisement and racial disparity in that is responsible for the disparities that you see. I think that's effectively mitigated by driver's licenses, which are, I've seen nothing to suggest that they're not race neutral. I know that the DOT doesn't actually collect racial data in terms of issuance of driver's licenses and non-driver's IDs, which makes sense because they just have a picture on them. And I think that it's important to be able to, because otherwise we could have a situation where there is substantial underrepresentation shown in the data, and whatever is being done to try to increase representation isn't working, but not as a result of anything that's inherent in the state's selection procedures, but for some other reason. And I don't have any idea what that could be. But I think it is important, if you're going to say that the state has violated the defendant's Sixth Amendment right, to be able to point to some state action that produced that result. And if the state is applying neutral selection criteria and is really doing its best to apply them in a neutral way and getting results that we don't expect, I don't know. And especially considering that when you ask the question, what's the remedy, what should the state do differently, people come up short, and I don't really know if there's a solution that, I mean, it's an important problem to address. I share the concern, and I just think that it's, in order to show a constitutional violation, that you have to show exclusion inherent in the state's selection
Counsel,
procedures.
I'm sorry to disappoint you, but I think we're going to change topics. I'd like to, I guess I'm troubled by the prosecutor's reference to Mr. Gray as the victim 34 times in the closing argument. Convince me that that's not a problem in this case.
So there's some confusion that results from conflating cases where the trial court in its instructions refers to a person as the victim and the prosecutor refers to the victim. The prosecutor's duty is one of spirited advocacy, that to argue inferences that are fairly established from the facts and the evidence, and to argue a particular interpretation of what the evidence shows. And one of those interpretations that flows fairly from the evidence here is that Mr. Gray was the victim, that the defendant did something that victimized Mr. Gray through those bolt cutters at his head.
Isn't that really a comment on the evidence, though? An opinion?
I don't think so any more than it is a comment on the evidence to say the defendant threw those bolt cutters at Mr. Gray. I think that it is a shorthand word to refer to Mr. Gray in that situation, and I don't think it's vouching. I don't think it's a comment on the evidence in a way that's improper. I think that it's an inference that fairly flows, and kind of I think that's treated pretty well in our brief, that we expect prosecutors to argue a fair inference from the facts, and the fact that the inference that Mr. Gray is the victim here is one of those fair inferences.
Mr. Sloven, let me shift to the implicit bias instruction. Did the state object to that instruction?
That's a really good question, and I'm not sure if the state actually objected to it. I think that they did and just asked that the model instructions be given. I think that the correct review I'm sorry, I see my time's expired. Thank you. Because those concepts are fairly embodied in the full instructional package, I don't think that omitting that instruction can be characterized as an error at law. I think that the trial court gets some discretion then in fashioning the instructions that it wants to give. Declining to mention race in that situation, I think is a risk-averse strategy, and I think is warranted if this court wants to provide guidance. And because part of the decision there was that the trial court didn't really have anything to go on whether submission of that instruction would create error. If this court wants to provide guidance for trial courts in future situations, I don't think there's any real problem with that. We included some research in our brief that sometimes it's better not to inject the issue, but it's for this court to decide. I think that the jury instructions very clearly communicated to the jurors that they're to decide exclusively based on the evidence, to give the defendant the full and fair presumption of innocence.
The jury instruction addresses the juror's conscious thought process, and implicit bias addresses the unconscious thought process. So where in the instructions are jurors asked to stop and consider if they can see how their unconscious thought process might weigh in this important decision-making?
I think they're instructed to consider only the evidence, and I think that puts the conscious thought process on a track to override, or instructs them that it should override whatever unconscious thought processes they have, that you can only decide based on your evaluation of the evidence and facts actually presented. The last jury instruction tells them it's their duty to find truth and do justice. I think that summarizes a lot of the concepts that are included. I really think that from the full instructional package, there's no real way to say that the jury could have been left with any impression that they could consider the race of any of the witnesses or the defendant in reaching their decision.
Thank you, Mr. Sloven. Mr. Dickey, rebuttal?
Mr. Chief Justice, and may it please the court, I understand that the potential impact of this case provides potentially profound issues for the judiciary. I would, in thinking of those policy implications, suggest some solutions which may not be necessary to decide the legal issue, but you know, to the extent that the data is available to the judiciary or to the state, you know, perhaps a task force that looks at the data over time and meets on a reoccurring basis to consider all of the statistical impacts might be a policy way of providing both the bench and the bar with more informed decision-making in addressing these issues. Or perhaps the legislature might be the proper avenue to do that. I would also add that whatever the decision is from the court, there needs to be some thought given to how this affects the criminal defense bar, who oftentimes do not get the jury list until 8 o'clock on the morning of a jury when they're thinking about voir dire, they're thinking about witnesses, opening statements, and the like. You know, to expect all of the criminal defense bar to understand binomial distribution may not be reasonable. I have looked at that issue, you know, for several hours, and I can't explain it without, except at a 50,000-foot level, and require the use of an Excel spreadsheet to perform any of the tabulations. So it's important to emphasize, I think, that if the defendant raises the issue contemporaneously with the impaneling of the jury veneer, but also emphasize the opportunity of post-trial practice or throughout the trial to accompany any challenge with some statistical expert testimony so that a record would be more developed for making these challenges on appeal. That would be an important aspect for this court to consider in fashioning a remedy in this case. To the extent that the court invokes constitutional avoidance, and I would really like for this court to decide the issue with respect to Jones, but the issue with respect to using the word victim 30 times is problematic. It is essentially the inverse of the Graves problem that this court decided several years ago, where it ruled that it's improper for a prosecutor to label a defendant as a liar multiple times. While that was a direct comment on the credibility of a witness, when you call a witness a victim or an accuser a victim multiple times, the negative corollary of that is that that person is telling the truth and the defendant's version is not truthful. So, you know, that is problematic in the sense that it is an indirect vouching for the evidence in the case. And with respect to the harmless error argument that's been raised by the court, it's important that this court emphasize and recognize that the harmless error analysis is not looking at the evidence in the record from the eyes of a juror in determining a defendant's guilt. It is looking at the evidence and determining whether or not it undermines the confidence in the outcome of the case. It is not a trial judge's you know, duty to sit in the shoes of a juror and weigh evidence. That would create a separate Sixth Amendment violation. And with respect to the implicit bias jury instruction, Mr. Chief Justice, this court has repeatedly emphasized that if a litigant to a case proposes a jury instruction that adequately states the law, then unless there are other reasons, compelling reasons not to, that instruction should be given.
Yeah, but now if it's redundant, and the argument is that, you know, there were other instructions that covered it adequately.
I think for the reasons that Mr. Chief Justice identified in his questions, that there's not a specific instruction that asks for subconscious, you know, decision-making implications of race, and this does, that before you reach your verdict, you have to ask yourself to make sure that you have a purity of thought that's not invoking any improper factors.
I understand the theory behind it, and I have a lot of respect for Judge Bennett. Has that been road tested? Have there been any studies done on this instruction, whether it makes a difference or not?
There's a law review article that we cited in our brief that talks about that. I don't know that there is any over time sample size where you could draw a statistically significant conclusion about it. What I would say is, to the extent it's redundant, I mean, you could give the marshalling instruction and then one other jury instruction that says do justice and decide the facts. And I don't think anybody on this court would think that that would be sufficient. And one last aspect to the instruction is there seems to be, you know, in the lower courts, this idea that if it is an instruction that's not in the model jury instruction set, there's a presumption that it shouldn't be given. And I understand there's a split on this court about that, but I think that flips it the wrong way, that at least by this court's case law, if it adequately states the law and it's applicable to the facts of the case, it should be given, regardless of what is or is not in the model instructions. So for those reasons, we ask this court to reverse Mr. Plain's conviction. Thank you.
Mr. Dickey, thank you as well. The case of State versus Plain is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.